Good evening, everyone, and a very warm welcome to the closing session of the SOAS Arbitration and Dispute Resolution Center's webinar series on international arbitration across Africa and Middle East. My name is Diane Okoko. I'm the managing partner of Marcus Okoko & Co. It's a firm in Abuja, Nigeria, and I do have the privilege of moderating today's session. This is session 3, by the way, of the series, and it is the last and the concluding session. And I'd like to say from the outset that I think the conveners have saved the most practical session, the question that should come first, but usually comes last, for the last session. Now, winning an arbitral award gets a great deal of attention. Converting it into cash, however, is a consideration that most people do not pay attention to. And yet that conversion is where the real test of the entire process actually does rest. Now, this is what we will be discussing today. And to do that, I will introduce my panel. I'll begin with, in no particular order, but how I see them on the screen. Tariq Khan. Tariq is a partner and head of international arbitration at M&Co Legal in the UAE. He specializes in complex cross-border disputes before the DIFC and ADGN courts. Tariq has a particularly strong enforcement practice. And this will come through when we get to speak with him and you hear from him. Next is Dr. Jean-Marie van de Elst. He's a managing director and practice area leader at Econ One Research. He brings an international finance and quantum expertise that spans C-suite corporate experience, investment state disputes, infrastructure disputes, energy, and public-private partnerships. Welcome, Jean-Marie. And I know that I did murder your surname, so I apologize. And last but certainly not the least is Dr. Amira Mahmoud. She is an international arbitrator and counsel. She's the founder of AM Attorney in Paris and a representative of the African Arab Arbitration Association in Europe, with a practice focus on cross-border commercial and investment disputes across Africa and the Middle East. Welcome, Amira. Thank you to the three of you for availing yourselves to be panelists today. And without further ado, now this evening, the question really is deceptively simple. From contracts to cash, how do you actually get there? Let's begin from the beginning. And I say from the beginning because the drafting of an arbitration clause is one of those moments in a transaction where most clients, are just thinking of getting the deal done. Very few actually are thinking about what happens if the deal falls apart. So this sounds like, contracting a marriage, but actually thinking of the divorce even at that contract stage. And fewer still think about whether the clause that they are signing will actually deliver an award that can be enforced in a forum where the other party's assets are or will be one day. So let's begin with a question I want to put to you, Tariq. As someone who has been on both sides of the experience, right, drafting the clause and then one who has come to enforce the award it has produced. Now, in your experience, what does an effective arbitration clause actually look like once you're the one trying to enforce in 5 years, say, the seats, the governing law, institution, language? What are the drafting choices really that most often decide whether conversion into cash is straightforward or becomes a battle?
Thank you, Diane. Thank you for your question. In fact, I've done enough number of workshops on this globally. And what I tell people is don't ask me how to draft an effective arbitration clause. ask me how not to draft an arbitration clause, because there cannot be a straitjacket formula for any arbitration clause. And anybody who sees a particular copy paste job, that's the one which actually gets into any kind of problem, because every contract has its own needs and parties really look for different things in different contracts. So I think that couple of things which I'll tell you, because I think you are asking me from the perspective of a practitioner who's enforcing awards day and night. And I think each jurisdiction has different challenges, but I have seen a lot of enforcement cases where we look at the clause that nobody is reading at the time of signing, and everybody wants to reread it 6 years later or 5 years later, usually in the middle of the night or in the middle of a meeting, because the other side has just moved its assets and some issues come up. So I think three things which are very important from a practitioner's perspective to anybody who's drafting a clause, to ensure that, once you get into dispute or when you are looking at a, enforcement, how do you really ensure that your nights are easy and not expensive? Because to give an effect to a pathological or inartistic arbitration clause can cause a lot of money and time just to get to know what was the actual intention of the parties. So I think most important part is to get the parties right, not just the signatories, the actual contracting entities with legal personality and identifiable assets. I mean, I have lost months chasing a group that never really existed as a legal entity, or a special purpose vehicle which had nothing in it. So if you're drafting for a group structure, either get a parent guarantee with its own arbitration agreement, or name the entity that will actually hold assets in 5 years. Nobody actually drafts for the balance sheets. So they should, in my view. And second aspect, very important, is the waiver language. It should be done properly. I want an express waiver of sovereign immunity from both suit and execution, where there is any state or state-owned entity involved. We have been seeing in DIFC issues where the questions of sovereign immunity keep coming up. And the DIFC is now, there have been recent judgments that you have seen involving Russia, for instance, where there is a Lugovoy law, and the IFC court passed a judgment that no, you have to participate because you signed this arbitration agreement. So I think any kind of waiver on any right to appeal or on the merits, to the extent that seat allows it, I think that should definitely be taken care of. And the parties to agree in the clause itself that the award is final and binding, and that they will not really encourage. I know it doesn't have the full meaning because ultimately it comes back to the jurisdiction. But good thing is, if you are putting a seat like DIFC, you know what you're getting into, because DIFC has been very active when it comes to giving, freezing orders or any aid in support of arbitration, any measures that you need. And they don't have a track record of interfering with awards. If I ask any practitioners in the last 20 years, you cannot probably point out more than 2 or 3 cases where they really interfered with the awards. So that's the reputation DIFC has built for itself. So this is the most important part, which I think that you need to draft a clause with the enforcement jurisdiction in mind, not just the seat. You should know where the assets are sitting. If it's sitting, for instance, in mainland Dubai or Abu Dhabi, then ask whether a DIFC seated arbitration or a DIFC as a conduit can give you a cleaner run than direct enforcement shore, on the onshore courts. So that is something you have to keep in mind, where the assets are located. So it's a strategic choice made at the stage of drafting, not at the stage of enforcement. And I have seen some clauses that were beautifully drafted for Paris or London, and they were hopeless, the moment the money turned out to be in Sharjah or in Ras Al Khaimah. So none of that really helped. So I think that's very important, how you choose the seat and what enforcement measures you are keeping in mind at that stage. The last thing which I think is important is getting the notice provisions tight. Bad notice clauses are the first thing any resisting debtor weaponizes to argue the arbitration was procedurally defective. So specify the number of arbitrators, make sure the language of the clause is wider to say that any dispute in connection with or in relation to is also covered, rather than simply saying, uh, you know, uh, that, I am somebody who is just going to deal with it. But I think if you keep it narrow, then, if there are connected contracts, they will become issues. We see every day the non-signatory says, you can't bind me, because the language of the clause is not wide enough. So I think that's something which I always recommend clients and in-house counsels. And more importantly, which I think people should be careful, is that in relation to not adding too many qualifications. There have been some dispute clauses where people have been writing things like the arbitrator shall have 15 years experience in marine engineering, should be fluent in Arabic and Russian. So those kind of, you make it impossible to find an arbitrator itself. So I think don't add so many qualifications for the arbitrator, and always try to keep a MAMADOU clause, because then you have an opportunity and a small window to first mediate before going to arbitration directly. So I think these are a couple of suggestions which I wanted to give. But in UAE, please don't put institutions which don't exist. A lot of big contracts which I'm seeing which are running into multi-million, there I see DIFC LCIA clauses which no longer exist. The institution is not there, but the clauses are being put still, and it becomes a big challenge for us as practitioners to really give effect to it, and a lot of money and time is lost. So enforcement, in my view, is decided by what the clause does, not say as much as what it does. So ambiguity is not neutral. It is an optionality for the resisting party, and they will use every gap you left.
Thank you very much, Tariq. So in a few minutes, what Tariq has done is give us a bird's eye view of what not to do. In essence, what Tariq has tried to tell us is about crafting an arbitration clause rather than just drafting one. Because when I hear Tariq say things such as, look at the institution itself and what is applicable in the institution, it goes beyond just the drafting, right? You are actually crafting a clause, working, from the back to where you want. Now, having heard that, Amira, with all of that Tariq has given us from the practitioner's view, from the enforcement end, I would like you to bring something to the fore. Now, perhaps, and pay attention to beyond the drafting stage, okay? And then I'll ask you, at the drafting stage, what choices most determine whether an award will actually be enforceable later? And how should a party think about the debtor's likely assets and the fora before a dispute ever even arises?
Thank you, Diane, and thank you for the introduction, and thank you for Professor Emilia to organize this with the SOS Center. Thank you for the audience. Good evening, everyone, or good morning. It depends where you are. So, building on Tariq's point, this session is about enforceability. So, we're going to focus on this, but it is sure that enforceability is strongly related to the drafting stage, which we have made a whole session for it. I invite you to go and have a look on the YouTube that is displayed, I think, on LinkedIn and YouTube. So it's only one word: foresight. Enforceability is decided the drafting table, not years after. Three choices matter actually most. First, the seat. You need to choose one that is both a New York Convention state and generally arbitration friendly. Because the narrower the ground to set an award aside, the safer your award. So this is the first thing that you have to think about, the seat, and that the state should be a New York Convention and friendly. Second, the law governing the arbitration agreement, because it is not always the law of the contract, and this is the law that will decide later on the validity of the arbitration clause and who is bound by it. So this distinction is really important. And third, and most overlooked, is the map of the debtor's assets before even you sign, because you have to know where is the money. Will those jurisdiction enforce actually? Is the state involved? In short, you draft with this last step which is the recovery already in your mind. So it's actually like a prenup. To take the example of the divorce before reflecting of the divorce option before stepping into a marriage. Sorry, Tariq, I don't know if you have done this. So this is really what I have to say about what you should pay attention to when you are thinking of the enforceability, starting from the drafting table. The 3 points that matters the most. That matter the
Thank you very much, Amira. So it's more about working with the end in mind, the seeds, the law, the map of where the assets are. Jean-Marie, you bring a financial perspective to this, that is sometimes missing from the purely legal conversation. Now, when a party is entering into a transaction and trying to protect its enforcement position, how does the financial aspect come into it? So tell us, within a multi-jurisdictional strategy, how can financial due diligence reduce enforcement risk, given that they are also risk advisors?
Thank you, Diane, and thank you for the invitation to this exciting panel, and especially hosted by Amelia and SOAS. Good morning, good afternoon, good evening. Tariq said it in very simple language. You draft for the balance sheet. It's the way that we look to start the process with counsel. So that means an early process. It's an early engagement. Too often experts are brought on board because the horse has bolted, and now we need to decide how much we're going to charge and claim for. And at the same time, where will we find it? We can go and claim hundreds of millions, but in the end, we might only recover a portion of that or a small portion of that. And what are the efficiencies in terms of the cost, the time? And something that has come across on more than one occasion, companies and clients often say to us, the parties that are involved in the dispute often do not appreciate the impact on the operations of a company in undertaking and supporting a claim. So this ties up operational people, it ties up operational assets, it takes their mind off what should be a business operation and now has to focus on the dispute resolution side. So early engagement, as you've heard, is important, and it's building a team with counsel. And that team, from our delivery point of view, resides on 3 tenets that we uniformly work with counsel. The first is that there has to be financial due diligence provided for in the drafting, in the contract. We want to be able to identify who the parties are, as Tariq clarified, whether they are in fact shells or special purpose vehicles, SPVs, very often the case in infrastructure projects involving public-private partnerships, and we've seen that in a number of exit cases that we've been involved with. And we also, from a practical point of view, within that financial due diligence, we look at the structure of the companies. Because if you see these fast-moving restructurations within corporations, it usually is a red flag. If we see tax vehicles that are located in interesting places, I won't mention too many names, there's many less of those today than there were, but they still exist. And, you have sandwich agreements, for example, typically between the Netherlands and Switzerland. And then you have the offshore havens that still do exist, but maybe not for fiscal purposes in terms of paying tax bills or meeting the tax obligations, but in terms of risk management on assets. So these assets are protected in a strange way because they're difficult to find, the traceability of those assets. And also that particular state might or might not be signed up to international treaties in which there is some repatriation possible. So the financial due diligence is simply more than just the legal rights. It reinforces the practicality. Secondly, we look to counsel to draft for evidential robustness. So there must be access to the first points of call: audited financial statements, board of director minutes. There must be a provision also on the parties to maintain these records, because often, a financial statement is as useful as the notes that are attached, and often we go and look at those notes and find more, but they're referred to working processes and decisions. And then we find that information is not available because the record keeping has not been of the standard to make that information reliable. So it goes beyond just whether it's just the drafting document, whether it's just the financial statements, it's the procedures and the record keeping discipline behind it, for example. Let me just get rid of this quickly. The third is to consider the recovery mechanisms. Where are these assets under which, and Tariq and Amira have referred to this, it's important to know this when you're drafting that contract, because you would probably, the lawyers, the counsels would amend the drafts to reflect some of the challenges that you understand, not the challenges you assume, but if you know where they are, you then draft for that. And Tariq mentioned Ras Al Khaimah. We've been involved in cases up there. So yes, we want to know what are the requirements to be able to recover those assets. And it's almost surely not in a cash format. So it's not in a liquid format. They would be fixed assets with different protections or title deeds restrictions. So it's important to know that what the local conditions and the local requirements are in terms of being able to attach those assets. In some constituencies we've been involved with where we've done asset tracing, we found where the assets are, but because they're of a particular nature, in this case they were land and buildings, there was a protection on being able to attach them because there was some public interest. There was some public right to the use of those assets, and therefore the client couldn't attach them. So I think in our practical experience, the most successful parties integrate both the legal drafting with the commercial and financial risk management from the beginning. It's all about not winning. It's about making sure that you can actually recover what you win right from the beginning. And it's a team effort.
Thank you very much. Thank you, Jean-Marie. So what I hear across all three of your answers is a consistent theme. Enforceability is not a problem you solve when the award comes. It's a problem that you either solve or actually do create at the drafting stage, right? With that foundation laid, let's turn to what happens when you've even won. So you have the award now. The tribunal has found in your favor, and then the reality of enforcement does begin. And in many cases, this is when the real battle starts, not even during the arbitration process. Now, I'd like to open up this segment with what I think is one of the most practically important questions. And I will begin with you, Amira, right? An award set aside at its seat, whether in the MENA region, an Ohada state, or elsewhere, can still be enforced in another jurisdiction. Why is that? And how far has the case law developed across Africa and the Middle East? And where does the French approach sit as a comparative reference point?
Well, Diane, as we said, an award is just a piece of paper. Until a court turns it into money, it's just a piece of paper. So, and the first surprise actually for many clients is that an award set aside at its seat is not necessarily dead. The reason lies in one word of the New York Convention. The Article 51E says a court may refuse to enforce an award that has been set aside at the seat. May, not must, may, which is permissive, not mandatory. And that single word has actually created two worlds. And France sits at the end. Actually, you have Article 7 of the Convention that gives the party the possibility to rely on a more favorable local regime. And French law has simply didn't simply list the annulment at the seat as a ground to refuse an enforcement. So an award annulled at its seat can still be enforced in France, provided the only one condition is that you need not to offend the French international public policy. That's it. This is the only condition. So French courts treat the international award as detached from the legal order of the seat. It's a kind of delocalization theory, a decision of international justice, in the words of the famous French case law Putrabili. And on this question, actually, yes, France is one of the most enforcement-friendly jurisdictions in the world. Of course, it's not the only one. Belgium, Netherlands, the US, case by case, but the most friendly jurisdiction, it is France. So back now to our region, to take this end of the spectrum to compare with the other regions. Egypt, for example, is more interesting than most people assume. Why? Because the Egyptian arbitration law lists only 3 grounds to refuse enforcement, actually. Conflict with the prior Egyptian judgment, a breach of public policy, and defective notification. The annulment at the seat is not at the list at all. So textually speaking, Egypt is closer to the French position than the strict reading of the convention. But honestly, Egyptian courts have not clearly embraced or recognized this delocalization French doctrine. They decide case by case, and in practice, mainly an award that is set aside abroad is often not recognized. But Egypt textually so open, practically cautious, we would say. So this is only about the gap between the text and the practice. This is the real story, but which hopefully, because there is no text that prohibit this option, maybe with a more developed and modern practice, the Egyptian position practically will also embrace the same trend as the French one, hopefully. But in a general manner, Egypt is efficient on the enforcement level. For a foreign convention award, you file directly at the Cairo Court of Appeal. It's the same condition without going through reviewing the merits. So the only 3 narrow grounds that I have mentioned. But now, if you go across the MENA region, I would say that annulment, there is no, not yet at least, a practice from which we can deduct a position on the annulment at the seat and what it can generate as a reaction in the MENA region. It is still the annulment at the seat still blocks enforcement. The lesson for anyone drafting or enforcing is simple. Where you seek enforcement is not a detail. It can decide literally the entire case. And maybe on this practice, I don't know if Tariq would give us a hint about the annulment at the seat. If in the UAE, for example, there is a case law regarding the annulment at the seat and what it may have as a consequences on the enforcement.
Very well said, Amira. Thank you for, giving us the comparison between the position of the French coup de cassation, the localization, doctrine, and that of Egypt. It's very refreshing to hear that, Egypt is also that progressive. So that brings me to Tariq, and knowing that Tariq, you do practice in one of the most developed enforcement jurisdictions, in the region. Now, I know that once an award is recognized, recognition, like we all know, is not yet cash. And I'd like to know from your perspective, what the practical tools available to stop assets moving before a debtor can react. So Tariq, once an award is recognized, what are the practical remedies available in the UAE and DFIC to stop assets moving before judgment debtors respond? The freezing orders, if any, travel bans, all of these things, what are your thoughts? Educate us on, this, all of these things when this happens, which is
Sure.
the award.
Thank you, Diane. And I think I'll just briefly answer in one line what Amira said. So in UAE, in DIFC, we see day and night people bringing awards where the challenge is pending in the seat. And if it's not in violation with the public policy, I have seen DIFC courts being very lenient, and they are upholding and enforcing and recognizing those awards. So even if it's pending challenge, it doesn't make a difference as long as it's a reasoned award. And because of the word may that has been used, what Amira rightly pointed. So if you bring me an award today from France, from China, from any part of the world, India, London, if it's pending, challenge in the seat, but if if it's a reason, so DIFC courts have been liberal because they're pro enforcement to another level, and which is what we see very frequently. So I don't see that as a challenge if you're enforcing it in the DIFC. But if you're taking it directly to the onshore courts, that may become a problem, which I don't want to touch right now. Now, coming back quickly to the question that you asked me about, how do you see the color of the money? Because that's the question everybody wants to know. And recognition, like Amira rightly said, is just a piece of paper. It's a paper tiger. And a lot of people really don't take it seriously because at the end of the day, cash is a different exercise entirely. And the moment you sense there is a dissipation risk, I think the only thing which really helps you is the speed, that matters. So I'll give you an example as well and how I do it. I'll give you a live example, which I was dealing very recently. This was a 650 million US dollars amount involved, and there was an award. And I was told that, the person against whom we are seeking is in UAE. When I got to know, I did not want to immediately file a notice, inform the other side. What I did, we got an ex parte freezing order from the DIFC courts. And what you have to convince to the DIFC court, because you asked me the tools which are available, and I'm giving you a live example, and this was one of the biggest disputes which I argued in DIFC. So you have to go under RDC Part 25. You have to give a full and frank disclosure to the court because it's an ex parte application. You're not serving anybody on notice, because if you move on notice, you have lost already. So the most important trick, and I would say the most important aspect, is that you have a strong case on merits. You know there is a real risk of dissipation of assets. The person is going to move around the assets by the time you know it. And there has to be a real risk, not any speculation that you have. So as long as you are giving the full disclosure, I have found the IFC courts being very lenient with granting the freezing orders. And this is ex parte that I got. And we did not serve the notice to the other party. So these applications, because of this very reason, because you want to first protect the asset, then you want to do anything else. So if it's a properly prepared application with a draft order, witness statement, you file it, and we filed it, and we had a hearing for about 2 hours, and we were able to convince the court. And the bigger challenge is the real risk of dissipation of assets whenever you are trying to get any freezing order from the DIFC courts. So you have to convince that what is the risk of dissipation of assets, and you have a good prima facie case. So we had an award in this case in our hand from a foreign country, and the amount was huge. So as soon as we got this, we immediately took a deputation letter from the court because the assets were in the mainland Dubai, not in DIFC. So as you know, DIFC and ADGM are free zones, but there is also mainland Dubai, which is governed by the onshore courts. So we were able to take this deputation letter, get it executed, and all the assets were frozen. And then we served the other side. So this is how first we protected the assets to ensure that we will be able to see the color of the money rather than first sending notice and doing everything else and then money is lost. The person disappears. So I think that's a very, very important tool which we have in DIFC courts. And if you do the strategy well, I think the DIFC courts are very comfortable granting these worldwide freezing orders in aid of DIFC recognized awards and increasingly comfortable granting them in aid of foreign seated arbitration proceedings, whether it is before, during, or after. So under the new DIFC courts law, if you want to read for academic purpose, I think the provision is 15 subsection 4, which says that, ongoing or future proceedings, you can always reach out to DIFC for any kind of support if DIFC is the seat. I think the other important aspect is when you are going to DIFC courts, you need to ask for a disclosure order, which usually sit alongside the freezing order, not after it. So you ask for a disclosure order in the same application, requiring the respondent to disclose their assets, their bank accounts, any third-party holdings within a set number of days. I think usually the courts give 7 days, and that disclosure is what lets you actually target the freeze rather than freezing blind. So then you actually get to know the assets of the debtor, what are their bank accounts, etc. And then you take it to the onshore courts, and then there is a notice issued to the central bank. And it's such an organized system. You are actually able to freeze their bank accounts also. So what we have done in this case, when we got the order from DIFC, we immediately took it to the local court and we executed it. So we were able to protect the asset. If you don't want to go to the DIFC courts, the other measure is in the local courts, you can file for a precautionary attachment. So it is similar to what we do in freezing orders. But of course, precautionary attachment is not the same. It is fast, but sometimes, it is not going to give you the same relief of disclosure. And it requires you to satisfy the local court that there is a real serious risk and there is a, final judgment or an award. And it is asset specific that you are attaching a named account or a named property. So it's not something which is casting a worldwide net. So that difference you need to understand. And then very important part which you do in UAE, once you have a freezing order or you have a final judgment, you immediately get a travel ban. So that travel ban is something I have seen working brilliantly because the parties are not able to travel. So they have to pay to be able to lift that travel ban. So as soon as there is an award or a judgment, our local litigation team immediately works well with us and they're able to secure a travel ban. So these are some things which we have seen. And in some matters, I have been able to get in DIFC court proceedings, in support of arbitration, positive injunction in 18 hours, I argued a matter. I mentioned at 6 o'clock, I got the instructions. And next morning at 11 a.m., I got it listed. The bundle, the witness statement were done overnight. None of us had slept. But the next morning, we had a stay in our hand. So the moment you are able to use these tools, they are available. As long as you understand how to make use of them, how to get matters listed, I think there is a lot you can do to really see the color of money.
Thank you, Tariq. So what I hear is the strategy is hinged on two things, foresight and speed, right? And this brings me to you, Jean-Marie, and let's talk about the intersection between legal strategy and financial planning, really. Now, given the divergent judicial approaches to awards annulled at the seat of arbitration, how can parties best integrate legal strategy with financial planning to maximize the prospects of recognition, enforcement, and ultimately converting an award into cash, seeing the color of money, as Tariq puts it?
Well, thank you, Diane. Using a travel ban seems to be very efficient, and is a broadside, but that's a practical approach, and that's exactly, to reiterate. Yes, you need to start early to to coordinate both the legal and the financial strategies. And if I may add to both Amira's and Tariq's points, we can get all this documentation and do all the analysis, but at the end of the day, it's trying to determine how much or what, first of all, what, because it might be fixed assets rather than liquid cash, to your point, Diane, but what and how much are you likely to recover, and is it efficient to go and, given the economics and the financial status of the claim, is it really worthwhile to get into a asset recovery that is not liquid, that is spread in multinational jurisdictions, that is probably going to take a number of years? And if you look at a realistic discount rate, let's just use 10%, which is often a vanilla option for the tribunals. You know, your maximum in any money that's recovered in 10 years is worth zero today at 10%. So it's that kind, and it, you know, even if your discount rate is 10%, what are the costs going to be? So, you know, if you're looking to recover 10 and your costs are going to be 3 and you're left with 7 and it's going to take you 5 years, you can do the simple arithmetics. Advice to counsel would be, no, it's not worth it. That doesn't mean that that's the end of the question. The question might be, well, why don't we look at a portfolio approach? Where are the group of assets that are most liquid and most reachable, if I can use that word? And we've done that. So we've said, okay, let's forego, there might be some very valuable assets further out beyond our reach. As a team now, we look at it and we say, we've done the due diligence. Here's the information. This is the financial due diligence that supports our feedback to counsel. And we say, given that lay of the land, if you wish, we will submit to you, why don't we chase these 3 classified the classes of assets in these 2 jurisdictions, which tick the boxes in terms of protection from the seats and the provisions and the jurisdictions themselves, but also being able to, as Tariq very practically clarified for us, apply some effective measures to be able first to secure them. But with respect to Tariq's point, we also want to convert them into liquid assets. We want to be able to realize them. Now, one of the things we currently involved in a case where one of the funders of this investment fund decided to call in his margin loans, but he's an investor as well. So an investor invests equity, which is on the different side of the balance sheet for most people understanding that. On the other side, you have your liabilities, and the liabilities include what is loaned to the company, so the creditors, and you would then decide, well, I have a loan that has a covenant, in other words, a condition that if you don't repay my loan, I'm going to attach your assets, the assets of the company. We'll be talking about the same investor, the same person, the same legal entity. So when we found that out, we said, well, let's go and look at these assets. And as Tariq will understand, many of them have been moved already, but we've kept track. And I think coming back to the early point, if you know where those assets are at the time that you're drafting, and you have a team that continually monitors, because you can do that, it's part of asset tracing discipline, I call it, it's much easier to track where they are moving rather than to start that tracking exercise much around the award or even after the award. So in this case, yes, we've been able to find where they are, and there's a proposal to counsel. But maybe we don't go after all of it. Let's be cost efficient at a present value requirement, and that's a very important matter, because sometimes we've had discussions with counsel where, the client wants to achieve, the large majority of the assets. he might recover most of those assets. Will he be able to convert them into liquidity and actually realize cash out of those? Probably not. And then we unpack that. So, and when would that be realizable? You know, is it in 10 years, 5 years, 2 years? Those are very, very, very important questions. The present value, the timing of the recovery is a difficult question to answer, but it's one that needs to be asked, because clients often get within the heat of the whole dispute resolution, the whole claim, the whole conflict, and are blindsided by the realistic realization of those assets into liquidity.
Thank you very much, Jean-Marie. So at this point, I'd like us to go really granular. And let me stick with you, Jean-Marie, and ask that you please, tell us in 2 minutes, what would be the 3 main priorities for practical value recovery enforcement? The things that make the difference between an award that becomes cash and one that becomes a piece of paper. 2 minutes, please, Jean-Marie.
2 minutes indeed. Don't wait until the award is rendered. I gave some very, very practical examples in terms of asset tracing. If you start that early, it's so much easier to track where they move, when they move, and in what format they are, because often assets change colors and change format. That, yeah. Number 2, the jurisdictions are fundamental, and whether it's New York or DIFC, we have a range of these across our experience, and it's important that those jurisdictions, from a legal strategy point of view, reinforce the practical financial processes that we will have to go through. If we don't have access to the financial accounts, or because the audits are not necessarily public, it's not going to help us. So those jurisdictions are really, really important. And then in terms of an international approach, let me give you we need a coordinated international approach, particularly where we have multinational and multi-jurisdictional disputes. Let me give you an example, and I come back to one of Tariq's points. Coming to council, looking to attach, and they're going now to the court with a request, and the court comes back and says, well, there's not enough information for us. And this was in the US, Miami. We don't have enough information to be able to grant this request. And counsel comes back and says, well, could you please assist? We said, sure. Why don't we take the multinational structure of the company that we're dealing with, the entity that we're dealing with, not just the representative offices around the world, but where they have assets and therefore risk exposure, and see where the possible web of asset transfers might extend to, and present that. Well, within an hour, they got the award. They got the request approved, because it was quite clear to the court that the risk, whether not a personal travel ban, but for asset title ban transfers, they had a view as to where these assets could possibly be transferred overnight, because it's all part of a holding company, which is opaque in its, of course. But the court found that it was much easier to understand and to visualize when they had this, what we call a spaghetti diagram of the shareholding, with some of the key balance sheet figures that showed that there was risk around, that meant that we could actually attach assets in other multinational institutions if we so chose. So I think those are the 3 main things. Coordinate international approach, prioritize your jurisdictions, and start your asset tracing early. But at the end of the day, it starts with a team. Working with counsel is a team decision, and it can be so rewarding when you are part of the same team, taking early decisions from a strategic point of view, not from a tactical point of view. And obviously it's frustrating when it's not the case, but hopefully that's not often the case.
Okay, thank you, Jean-Marie. So holding on to your last point as to working with counsel, I will come to Tariq. right? So Tariq, you have used the DFIC as a conduit jurisdiction to get awards recognized before enforcing onshore in the UAE. In 2 minutes, can you walk us through how that route actually works in practice? The
Sure.
key procedural steps, everything. 2 minutes. I know I said
Sure.
everything, but 2 minutes.
Sure. So see, once we have an award or a judgment that we want to enforce, we have two options. Either we directly go to the local court where the assets are, get it recognized and enforced there directly, or we use the DIFC court first as a conduit, because DIFC courts, because it's a free zone, they have an MOU with the local courts, which says that any judgment which is recognized by DIFC courts will, as it is, be enforced by the local courts. They will not look behind it. So that makes life easier for you. Now, let me give you a practical example. There was a French judgment which had come, and that involved issues of non-signatory being made a party. Now, if I took this directly to the local courts to explain to the local judge what non-signatory is, it's a concept which they're not very privy, and they may not enforce an award like that. Why you have put somebody who was not a signatory, a party, and award is against them. So first I suggested to the team, let's increase more cost for the client, because it's important that first we convert it into a DIFC court. They understand common law principles being DIFC courts. So we took it to the DIFC first. DIFC recognized that award, put a stamp of DIFC on that. And the moment DIFC recognizes an award, it enters, the judgment in its own terms. So now this thing has become a DIFC judgment certified by DIFC. I am now going to give it to my local onshore team, the lawyers from UAE, who will then take it to the onshore court with a deputation letter. In Arabic it is translated, and then this judgment of DIFC court is enforced simply without any hassle by virtue of this memorandum of understanding. So how DIFC is now helping globally as an enforcement conduit, because DIFC gives you best of both the worlds. First, it is giving you the best of civil law countries because of Riyadh Convention, GCC Convention. Any judgment of GCC countries, you can take a DIFC court judgment and enforce it in any civil law countries. Similarly, you can take it common law to common law. You can enforce it in Singapore, you can enforce it in London. So DIFC judgments, first, if you convert any judgment and you make it a DIFC judgment, it can be enforced in, I think, more than 150 countries by virtue of civil law plus common law combination. And you don't really have to go through hassle of any treaties between the country. So I think in that sense, DIFC is really doing a good job. And a lot of people are coming this route rather than directly taking it to another country. They first convert it by using this conduit jurisdiction, and then they take it to enforce where the assets are.
Great. So that brings me to an angle of enforcement that we all as practitioners try to run away from, but there is no running away from, and that's sovereign immunity. So Amira, I'd like to find out from you, how does sovereign immunity and enforcement against states or state entities play out across Africa and the Middle East? And what practical steps can turn a favorable award against a sovereign or a parastatal of that sovereign into real recovery?
Oh, okay. Well, Diane, when you enforce against the state, there are actually two immunities, and people confuse them generally. The first is the immunity from jurisdiction. Can you bring at all the claim? And that is usually waived by the arbitration agreement itself, as even Tariq has highlighted. The second is immunity from execution. Can you actually seize the state's assets? And that is the real battleground. You can hold a perfectly valid award and still be unable to touch a single asset. So the key is the nature of the assets. Assets used for commercial activity are generally seizable. I mean, in the context of a state. Assets serving sovereign functions, meaning embassies or central bank reserves or any military property, those are protected. So you cannot touch them. So recovery against a state becomes in practice a hunt for only commercial assets in the right jurisdiction at the right moment. This is where I refer to what has said Jean-Marie, the jurisdiction and the timing. You have to be speed and you have to choose the right jurisdiction. So place and location. Those are really important criteria to think about very, very, very early. And there is a real recent, if we want to compare, for example, this aspect on the African level, the African side, the OHADA Enforcement Act was revised since February 2024, and there is a new Article 13, if I'm not wrong, that has narrowed immunity from execution, which meaning that it reserves immunity to the state and public bodies only, and in principle removes it from the state-owned entities, enterprise, sorry. So that is set up in a corporate form. So for creditors across 17 African states, that is really a significant opening. So when we are talking about states, we need to have on mind this important distinction between the immunity from jurisdiction and the immunity from execution. On the Gulf level, there are also enforcement that are layered because we have so many layers. And this is maybe something that Tariq is far better placed than me to describe, because it's not only about the New York Convention, but you have also the GCC Convention and Riyadh Convention. So it is a different structure. But yes, if you are handling a state, this is, as you said, it's not the best case scenario, but still a state can have the double hat as a commercial agent and have commercial assets. And this is what you should have on your mind when still, again, you are drafting a contract with a state company, for example. So we go back again to the drafting when you think about the enforcement. And for this, I have very quickly an example from my practice that's worth mentioning, because I'm currently handling enforcement strategy.
Amira, I'm so sorry, but at this point, we are
Running
almost
out
running
of
out of
time.
time. So I will give all of you 1 minute each. Unfortunately,
to
we do not
closing.
even have time to take questions, but thankfully, I don't see that there are any questions for us to address. I think, all of you.
Sorry, Diane, you can take 10 more minutes.
Oh, perfect.
We can top it up. It's really, really very interesting. You guys are really helping. So please, we would be happy to give you 10 more minutes, please.
Thank you so much, Professor Emilia. Thank you so much. So, Amira, take it away. Tell us that, what story you were just going to.
I can put it in the closing 1 minute, so we can start by this if you want. I was talking about yes, an example that illustrates the importance of the choice of the place and the timing, because I am working on a case that is actually multi-jurisdiction between Middle East, Europe, and Africa. Exactly the best example that can really highlight this, and it's worth millions of euros. So the arbitration itself, it's over 20 years ago even. So this is how much it could take to enforce cash, and still we are working on the enforcement. Why? Because all of what we have said, everything that shouldn't have been put in the clause were put in the clause. So you have to go around many obstacles, and you have to identify through jurisdiction what you can do or not to see the cash. And here is where I think the moment they were negotiating the contract, because they come from two different regions, each wanted to have the seat in his region, and maybe one has won this argument, so the seat now in a certain country, for example, in the African continent, but as it was set aside, it cannot be enforced in the whole 17 African countries. So he won the place, the seats in the contract, but not the cash, because the seat is not the cash. He should, or she should, whoever is contracting, have thought about where are the money before, and which jurisdiction could accept an annulment, or where are the monies. Starting from this, where are the money before choosing the seat for the jurisdiction seat, actually. So if there is only one thing to take away, and I will close with this, is that enforcement is won or lost long before the award. Choose the seat with annulment risk in mind. Map the debtor's assets before you sign. Remember that where you enforce can matter more than where you won. An award set aside at its seat is not the end of the road. And in some jurisdictions, and in France and increasingly in other parts of the world, it can still become cash. The whole lesson is foresight. Think about the last step, recovery, at the very first step, drafting. Voilà.
Thank you. Thank you so much. Tariq, your parting shots?
Sure. So I think the first takeaway for me would be draft for the balance sheet, like I mentioned earlier, not for the letterhead. Before signing, ask one question: where this counterparty's actual recoverable assets will sit in next 5 or 6 years, not where its head office is based. Name that entity that will have the money at the end of the day, and if possible, get a parent guarantee if the signatory is thin. And if assets are likely onshore, for instance, in UAE, structure the seat or a DIFC nexus into the clause right now. The second most important point is build your dissipation file before you even need it. Don't come to the court first, do it, and then you start finding evidence. The file should be ready first. And I always tell people the difference between an ex parte freezing order granted within 24 hours, which we have secured many times, and the one which is refused is not just urgency. The difference is the evidence. So the moment dispute turns adversarial, please start documenting the counterparty's asset movements, corporate restructurings, payment history, because at the end of the day, the judge asked me one question. The judge wants to know, where is your file? Where is the paper trail? It has to be ready before you file anything in the court. Don't start finding evidence once you have filed. Do your job first and then file. The third and most important is, get your constitution of the tribunal and the notice provisions in the contract airtight, because I think improperly constituted tribunal and defective notice are the two most litigated Article 5 grounds for resisting enforcement. So please specify that very clearly. And last but not the least, sequence your enforcement. Do not scatter it. Widest net has to go first. A worldwide freezing order is your widest net. When you are fishing, you're putting your wider nest. So that net will really get you all the assets with the disclosure which is attached to it. And that disclosure then you use to decide how you want to attack in onshore, offshore, which country, because a worldwide freezing order will disclose all the assets. So please sequence your enforcement accordingly. Do not scatter it. Do not alarm them. Otherwise, they'll start moving assets. So that's the only thing I could think of.
Thank you very much, Tariq. So I must apologize on behalf of Jean-Marie. He's had to catch a flight now, and this is the reason that he needed to drop off on the dot of an hour. He did sacrifice to be here with us on his way to the airport. So my apologies on behalf of Jean-Marie. So it is very clear that the idea really of enforcement actually does begin at the drafting stage. Now, not just drafting for the sake of drafting, but drafting with the end in mind. This tells us as counsel that our job is not just to draft, an enforceable clause, but it is to draft a clause that translates into cash. So you must begin with the due diligence of where the assets possibly could be, before even coming back to, choosing the seat. And on this note, I will thank every single panelist, to Tariq, to Jean-Marie, Amira. Each of you brought a depth and a specificity to this conversation. And I do not think you often find in one panel, at the same time. I really am grateful. We also must thank Professor Emilia Onyema, also Dr. Amira, for convening this series, and the SOAS Arbitration and Dispute Resolution Center as well for this platform. Now, for those of you joining us from everywhere across the globe, we say thank you. Your presence, although you didn't ask us any questions, made this session.
You have one question in the chat.
No questions?
Okay. So
there's one in the chat. And Mark, I don't know if you want to unmute and ask your question.
Please, by all means.
Sorry,
I can't find the question. I see Mohammed's question. So if it's you, Mark, please just go ahead to ask the question.
Yeah, no, thank you. Thank you so much for this opportunity. And thank you all for what's been a very excellent, engaging and fascinating discussion. I've truly learned a lot. So my question sort of goes back to the initial discussion on how, even when we're thinking about the enforcement, we have to start from the stage of drafting. And really my question was, in a practical sense, when you're drafting, the clauses within the contract, including the arbitration clause for your client, and the party they're engaging with, commercially or as it may be, has assets in a jurisdiction that may not be arbitration or enforcement friendly. At that early stage, obviously bearing in mind that this is a stage where the parties are very happy and not really thinking about the worst case scenario, how would you advise your client to proceed in that situation, given that, if anything were to go wrong, it may be very difficult to enforce any arbitral award that you would get? Thanks.
Tariq, you want to begin?
Sure. I think that's a very important question. See, in all honesty, I think the first thing that I always check whenever any contract is happening, whether there is any treaty between the two jurisdictions, because I always try to see what will be there if there is a judgment from UAE, and if UAE has a judgment with, say, India. And India is a very difficult jurisdiction to enforce awards, right? And to get the color of the money. You may be stuck for 10 years or 6 years. And if UAE has a treaty with India, it may become easier to enforce it, because then you're not going through the route of getting that recognition first and converting it into a civil judgment of that local country. So I honestly think that it's the most important point that you check the treaty and reciprocity position precisely, not just casually or generally. The other thing which I have to be very honest with you, and I advise my clients, even if they don't want to hear it, I say that, look, a debtor with a real property in a hostile jurisdiction or in not so friendly arbitration jurisdiction and nothing else exposed, is actually a weak enforcement position for you. However solid the assets may look on the paper, you need the leverage, the local courts, and you don't know the approach of the local courts. So I think to see the pressure points, you need to see where the bank accounts are, the receivable group entities, the reputational and operational pressure points, where anywhere in the enforcement friendly jurisdictions, even though the hostile jurisdiction may not have it, but there may be something to do with other jurisdiction, which I told you these criteria, some bank accounts in other countries, or maybe some reputational and operational pressure points. So I think those things we consider and we advise accordingly. But at the end of the day, like you rightly said, when parties are entering into a contract, the last thing on their mind is a dispute. And the first thing when we get into a dispute is, oh, let's see what we have drafted. So nobody really wants to talk to disputes lawyer. That's the sad story. And today only I was telling somebody, next time you sign into a contract, please just show it to us once. They don't even want to see whether it is an operable arbitration clause or not. And Professor Emilia obviously will agree with me, being one of the leading practitioners, you would have seen it many times. So yeah.
Thank you.
Thank you very much, Tariq. And, to add to what you've just said, so we had this contract we were drafting, and because the particular client is really headstrong. You know, Mark, what we had to do was commission independent, you know, financial advisors to go trace the assets. And we brought this to his attention even before, because we knew what was at stake for him, right? And if we didn't show him this report ahead of even the drafting, we know him enough to know that he would not listen. So we had to do that tracing and then come back to him as to why we were suggesting certain seats as against others, right? So things like this, sometimes you need to take it on by yourself. Amira, you'd like to add something to this?
I would confirm everything you have said, because it's practically, this is what usually we lawyers are maybe a bit different than in-house, in the sense that we are a bit paranoid. So we are always thinking of what will happen, the worst case scenario before the best case scenario. The in-house counsel, they are always in the honeymoon phase. Okay, everything is bright, everything is beautiful, but and they even refuse to think about it. Really, they refuse even the probability to think about it when they are negotiating, because they are in a hurry to go into the deal, and they don't want to think about any potential disruption or conflict or whatsoever. And then they come back. So, and you have to clean the mess after it, because it's not always straight. It is always actually not straightforward. And the example of the case I'm working on, when I tell you there has been more than 20 years, they are trying to enforce an award that has the exequatur, but just set aside in one jurisdiction. That this is a really concrete example. But hopefully we're working on this, and as we said, in our region, there is nothing textually that is very narrow, and it can be modernized. I know that in London, both Emilia and Diane can confirm this, that it's the opposite position regarding the enforcement. But this is another story. So to end, yes, you have to be a bit Machiavellic. Voilà.
Absolutely, absolutely. So again, thank you so much. We cannot thank, you know, the SOAS Arbitration Dispute Resolution Center enough for putting these series together. Regrettably, this is the last of the series for now. Fingers crossed. Fingers crossed there will be more in the coming months. And thank you, Professor Emilia. Thank you to my panelists, every single one of you, to the attendees. Thank you so much for making out the time. Without you, there will be no webinar. And on this note, I will bid everyone a good evening and, well, good morning to some, wherever you are, and then have a beautiful rest of the day. Thank you.
Thank you, Diane.
Thank you, Professor
Thank
Emilia.
you.
Thank
Thank
you.
you. Thank you.
Thank you, everyone.
Thank you, everyone. Thank you.